So the judge in the Lively Wayfarer case has done some housekeeping today. Let's talk about it. There were a number of documents filed by either Lively or the Wayfarer parties that were deemed sealed or provisionally filed as sealed, and on many of those, one of the parties moved for continued sealing or opposed the sealing. And so the court is addressing all of those documents, sort of a clean the house type of order. Most of this is pretty standard. So with respect to documents that were provisionally filed under seal, but no party moved to either prevent sealing or to proceed with continued sealing, the judge has said or ruled that it doesn't look like you actually wanted it to seal because you didn't file anything since the date that you originally provisionally filed this as sealed. So he removed the seal designation and ordered them to be unsealed to the public. The one that is a little bit sticky was with respect to the recording that was filed in connection with Lively's 47.1 motion for fees and sanctions. And they had included a recording of Steve Sarowitz with an unnamed declarant that allegedly declared or would testify that had been verbally abused by Baldoni at some point. They put segments of the transcript of that recording into the document, into the motion, but didn't actually provide the full context or provide the full transcript of that. Also had redacted the name of the declarant. So the court weighed the presumption against sealing. So the presumption is that documents should be made available to the public. So when you utilize the court system is a public vehicle. When you utilize the court system, there's a presumption that those documents be made available to the public. Now, typically speaking, people aren't breathing down the neck of the docket, but when you utilize the court system, you should expect that this would all be made public. It's all publicly available. So there is case law that supports a presumption that anything you file in the court should be made available to the public. Now, in instances where a third party's rights or very, very sensitive information could come out that would cause more harm to a person than the good of making it available to the public, then that presumption can be overcome. But simply because the declarant doesn't want their name out there would not be enough. And here the court is saying that the declarant chose to provide an affidavit with this information. So willingly is participating in this, knowing that there's a presumption that this information would be made public, and Lively did not make a showing that there is this grave harm, for example, to the third party that provided the affidavit. So for that reason, he ruled that he would unseal not only the affidavit showing the declarant's name, but also the full transcript of that recording. The other slightly contentious one was Wayfarer's request for continued sealing of documents, exhibits filed in support of their MJOP, motion for judgment on the pleadings. And those exhibits were, one, an agreement between Blakel Inc. and It Ends With Us Movie LLC, and Exhibit 2, which was the complaint and right to sue letter filed with the CRD. And the judge here says that Wayfarer didn't elaborate in detail why this information is sensitive. So Wayfarer came and said that there's some sensitive information here. They would like to have it continue to be sealed. Because the judge didn't see their arguments as sufficiently in detail, he's allowed them until tomorrow, October 8th, to provide a justification for why that information should in fact remain under seal. So we'll see a letter filed by Wayfarer by tomorrow explaining that. A question that I see floating around is with respect to SDNY, the Southern District of New York's recent notice that was sent out with respect to the filing of sealed documents within that district court. I took a look at that, and it looks like it really relates to sealed documents in particular. So previously, sealed documents would be available to the parties via PDF online through ECF Pacer, the system that lawyers use when filing documents. The only thing that changes now is that those sealed documents are not going to be available via PDF for the parties anymore. They have to rely on copies, if they want electronic copies, copies that are shared by their adversary. So anytime you file something with the court, you serve the other side, you provide a copy to the other side. So what this change is simply that you can't view the PDF of a sealed document through ECF Pacer anymore, and you should get it just from the parties. This doesn't change the experience of the public, because the public will never see sealed documents anyways, so there's no change for our experience of this case, because once it's sealed, we wouldn't have been able to see it anyways. So that's hopefully will answer that question. As to unsealed documents, those should show up on the public within the next day or so. So unless I'm misunderstanding this, I don't see it affecting unsealed documents.